Good afternoon and welcome to this webinar on sexual harassment and discrimination. Know Your Rights, delivered by the ISM Trust. I'm Simone Braithwaite, Legal Advisor here at the ISM. Before we begin, a few technical points. You can't see me, but you should be able to see the PowerPoint presentation displayed on your screen. You should also be able to hear me, but I can't hear you. If you experience any technical difficulties such as sound quality issues, please let us know by email and we will make attempts to resolve the issue. This webinar is being recorded and will be available to view on the ISM's website at ism.org/webinars. For those of you who maybe don't know us, the Incorporated Society of Musicians, or the ISM, was established in 1882 to promote the art of music and to support professional musicians. Now, some 135 years later, we support a membership of almost 8,500 music professionals of all kinds, which consists of teachers, performers, composers, and many more besides, with legal advice and representation, tax and business advice, and award-winning professional development opportunities, along with campaigning and advocacy for the music sector as a whole. Through our sister charity, the ISM Trust, we have established a means to share our experience and expertise with musicians beyond just those who are ISM members. And this webinar is part of the Trust's professional development opportunities, open to all musicians. So in this session, I'm going to be giving you an explanation about the law governing sexual harassment and some aspects of discrimination law and your rights. I hope you find the information helpful. It will be available on our website at ism.org shortly after this webinar. To start with, I thought I should give you some background context to this webinar. Last autumn saw many revelations regarding inappropriate behaviour in many different settings. New revelations continue to appear in the media, and there has been a huge response globally to what we have been hearing. Unfortunately, concerns have also been raised within the music sector about incidents of discrimination, including sexual harassment. The ISM, as the UK's professional body for musicians, is firmly committed to equality and best practice in the music industry. These revelations prompted us to conclude that what was needed was a cultural change in the music world. Our first step in formulating a way forward was to ask musicians to offer their suggestions about how we can improve the culture and conditions in which musicians work, and to share their experiences with us on a completely anonymous basis. With that in mind, in November 2017, we launched a survey which is currently still open for responses. In the meantime, we have released an interim report outlining the initial findings. The results of this survey have revealed a pattern of discriminatory behaviour in a broad range of workplaces. What is particularly troubling is the extent of sexual harassment within the music sector. Almost 65% of respondents who had experienced discrimination reported that they had been subject to sexual harassment. 72% of these respondents who answered regarding their employment status were self-employed. 77% of these respondents did not report their experiences, with fear of losing work far outweighing any other reason for not doing so. This fear was not limited to just sexual harassment, but a common theme across all types of discriminations, as the survey results highlight. In the ISM's view, the solution needs to address the realities of the music sector and how it works. So we are calling for a change in the culture across the whole of the music sector, starting in educational settings, from schools up to and including music colleges. There needs to be absolute clarity as to what behaviour is acceptable and what is not. There also needs to be absolute clarity in relation to the structures in place that support musicians in their work, including processes whereby musicians can report their concerns without fear or retribution or judgment. We also believe that all the above needs to be underpinned by a sector-wide code, which is recognised by all who work in the music sector. However, What our survey also uncovered was musicians' call for more training to be available so that everyone working in the music sector can understand their rights and duties. This webinar is part of that process. You can view our interim report at ism.org/dignity at work. The purpose of this webinar is also to create some awareness of the rights you may have under the legislation governing discrimination and sexual harassment in the workplace, depending on your employment status. I will go through the relevant sections of the Equality Act 2010, which is the piece of legislation which consolidated all of the existing discrimination laws pre the 1st of October 2010, when the Equality Act came into force. Moving on to the issue of who is protected by the Act. Firstly, there are various categories of persons who are protected from harassment or discrimination under the Equality Act. For the purposes of the webinar, I will discuss the relevant categories of those who are protected within the Act, such as employees and workers, and the provisions which can be relied upon by freelancers, that is, those who are self-employed and providing a service. There are also a number of organisations which can assist with providing you with help and support which you may require if you have experienced discrimination or sexual harassment. I will provide you with these details towards the end. The Equality Act came into force in October 2010. It replaced previous anti-discrimination laws with a single act. Its aim essentially was to simplify the law, remove inconsistencies, and make it easier for people to understand and comply with. It also strengthens the law in important ways to help tackle discrimination and inequality. Under the Equality Act, there are 9 protected characteristics, which is how I will refer to them throughout the remainder of the webinar. They are age, disability, gender reassignment, marriage and civil partnerships, pregnancy and maternity, race, religion or belief, sex, and sexual orientation. This means that discrimination on the grounds of any of the protected characteristics is unlawful. So discrimination means being treated unfairly because of who you are. The Equality Act protects you from discrimination by employers, businesses and organisations which provide goods or services like banks, shops and utility companies, health and care providers like hospitals and care homes, someone you rent or buy a property from like housing associations and estate agents, schools, colleges and other education providers, transport services like buses, trains and taxis, and public bodies like government departments and local authorities. Incidences of discrimination can also arise because of discrimination by association or perception. This means that an individual doesn't have to have a protected characteristic to be protected, but if they are treated less favourably because of their close connection or strong association with someone who has a protected characteristic, for example, a family member, or because someone thinks they have a protected characteristic, but they don't. So what does the legislation say? There are 4 types of discrimination which I'm going to discuss. Some of the concepts apply to all of the other protected characteristics, but for the purposes of this webinar, I'm going to focus on sex discrimination. So firstly, direct discrimination. This occurs when you are treated worse than someone of the opposite sex who is in a similar situation because of sex. Secondly, indirect discrimination. This happens when an organisation has a particular policy or way of working that is applicable in the same way to both sexes, but which has the effect of putting you at a disadvantage because of your sex. For example, a job requiring full-time hours will potentially be discriminatory against women, as they are more likely to have childcare arrangements to manage, making a full-time role an option they are unable to consider. Moving on thirdly to harassment. This is unlawful under the Equality Act, but there are three types of harassment relating to sex, which I have categorised as A, B and C on the slide. A relates to any of the 9 protected characteristics where someone is harassed, causing them to feel offended, humiliated or degraded. The second type, that is B on the slide, is sexual harassment. This is when someone makes you feel offended, humiliated or degraded because they have treated you in a sexual way. This is also referred to as unwanted conduct of a sexual nature and includes verbal and physical treatment such as jokes, touching or assault, as well as sending emails of a sexual nature or displaying indecent images. And the third type of harassment, C on the slide, is when someone treats you unfairly because of your refusal to accept or put up with sexual harassment. Moving on now to victimization. This is when you are treated badly because you have made a complaint of sex-related discrimination under the Equality Act. This can also arise where you have supported someone who has made a complaint of sex discrimination. So who is protected? I'll now look at who is protected from discrimination and sexual harassment under the Equality Act. In today's world of work, there are various types of working arrangements which an individual can have with one or several organisations. Working schedules are now different to what was at one time the traditional 9-to-5 working arrangements. As a result, there are defined categories of individuals based upon how they work, what is stated in their contract, what they are responsible for, which could mean the duties they are required to undertake, or possibly in relation to payment of tax and national insurance contributions. I will look at 3 categories and the circumstances in which protection is acquired under the legislation and other situations where it is not. Firstly, employees. The most statutory employment rights apply only to employees. These rights include redundancy pay, sick pay, holiday pay. An employee will have the following: a contract, which need not be in writing and can be implied, a requirement for the work to be done in person, for example, you cannot send a substitute in your place, mutuality, that is each party being under an obligation to the other, the employer to provide work and on the employee to undertake that work, control by the employer of the way or circumstances in which the work is done. Moving on to the category of workers. Legislation recognises the category of workers who are neither employees nor self-employed. The definition of worker includes, in addition to employees and apprentices, those persons who have a contract whereby the individual undertakes to do or perform personally any work or services for another party who is not a client or customer of the business, undertaken, carried on by the worker. The key to worker status is providing personal service. That is, there is no right or only a limited right to send a substitute in his or her place. Workers have some of the employment rights afforded to employees, including those relating to the minimum wage and paid holiday, but their rights are less extensive than those of employees. Moving now on to freelancers or the self-employed person. So the key to self-employment is that individual is running his or her own business, in which case he or she is not entitled to any of the statutory employment protection rights afforded to employees or to workers. The contract between the parties will be for the provision of services, and terms that indicate employment such as sickness, holiday, discipline and grievance do not apply. A self-employed person will be paid only for the work done, paid a fee, not a wage, and responsible for his or her own tax liability. Although do note that a person can be both employed and self-employed at the same time. This could be because they work part-time for an employer and they run their own business part-time. Self-employed people work for themselves. A self-employed person is therefore not an employee. In general terms, employment legislation does not apply. A self-employed person may, of course, employ staff and become subject to employment law. This situation does not alter the fact that the law, for the most part, does not cover anyone with self-employed status. So in summary, if you are an employee or a worker providing a personal service, you are protected by the Equality Act. The Advisory, Conciliation and Arbitration Service, also known as ACAS, which is how we'll now refer to them throughout the remainder of the webinar, in their guidance on equality and discrimination, state that in relation to discrimination matters under the Equality Act, the definition of employee is extended to include employees, that's those with a contract of employment, workers and agency workers, that is those with a contract to do work or provide services, apprentices, so those with a contract of apprenticeship, and some self-employed people where they have to personally perform the work. The guidance explains that employees are protected against sexual harassment, which is unwanted conduct that is of a sexual nature and or relates to the protected characteristics of sex. Examples may be either verbal or physical and may include staring or leering or a display of explicit material. It would have the purpose or effect of violating the employee's dignity or creating an environment for the employee which is intimidating, hostile, degrading, humiliating or offensive. It also applies where an employee is treated less favourably because they have rejected sexual harassment or been the victim of it. An employer should make clear to employees what sort of behaviour would be considered sexual harassment. Sexual harassment may be both an employment rights matter and a criminal matter, such as in sexual assault allegations. If you experience inappropriate behaviour at work and are an employee or worker, the ACAS advice and guidance on sexual harassment suggests that you report the incident and make a complaint. Firstly, you will need to check any policies which the organisation has on sexual harassment to identify who the complaint should be made to under the harassment and bullying policy. Many organisations will suggest that a formal written complaint is made using the grievance procedure to the appropriate supervisor or manager. There may also be other individuals within the organisation, such as a member of human resources with specialist training. There may be a nominated fair treatment contact person within the organisation, or if you are a member of a professional association or trade union, seek advice from your representative. Prior to speaking to someone, it may be useful to make notes about the incident for your records, and particularly if you find repeating details of the incident too distressing, you will have a written note to make reference to, or you can also provide a copy. If you've been discriminated against at work and you've not been able to sort things out with your employer, you can make a discrimination claim in the employment tribunal. The normal time limit for making your discrimination claim in the tribunal is 3 months less 1 day from the date when the discrimination happened. But before making your claim, you must put in a request to ACAS for early conciliation. This will affect the time limit for presenting your claim. During the conciliation process, the time limit is paused and extended. In order to bring a successful claim in the Employment Tribunal under the Equality Act, an employee must be able to show that they suffered a detriment and less favourable treatment. A detriment is unfair action taken by an employer against an employee during employment, but does not go as far as dismissing the employee. This could be demeaning or humiliating comments being made if the comments are based on your sex. Workers are protected from suffering a detriment because they have done something where they are protected by law. For example, they should not be picked on by their employer because they have tried to assert their legal rights. While the Equality Act protects against harassment related to most protected characteristics, other legislation such as the Protection from Harassment Act 1997 may also apply. This legislation is not limited to circumstances where harassment relates to a protected characteristic. Harassment under the Protection from Harassment Act must amount to conduct which is criminal. Claims under this Act are brought in the civil court and not the employment tribunal. There are various ways of getting support should you have concerns about sexual harassment and discrimination in the workplace. As an ISM member, you can get in touch with our in-house legal team as well as our 24-hour legal helpline should you require advice outside office hours. Victim support have a useful website with helpful resources and advice. The Samaritans offer emotional support primarily through their 24-hour helpline. There are also other ways to get in touch with them for assistance, which are all available on their website. The police should be contacted if you need to report a sexual assault or are in immediate danger. Alternatively, you can call 101 in a non-emergency situation. The Equality Advisory and Support Service have a helpline which advises and assists individuals on issues relating to equality and human rights. ACAS provides free and impartial information and advice to employers and employees on all aspects of workplace relations and employment law. They support good relationships between employers and employees. In addition, when things go wrong, they help by providing conciliation to resolve disputes and problems at work. They also have a useful online helpline. And lastly, the Citizens Advice Bureau provides free, confidential and independent advice to assist people with various legal issues. Thank you very much for listening. This webinar will be available on the ISM website shortly, as well as various information on the ISM's ongoing campaign on discrimination and harassment in the music industry.